All right, so I think everyone probably already knows about I-9s generally. Just in case you don't, a quick refresher. An I-9 form, of course, was established by Congress. It is a result of federal law, the Immigration Reform and Control Act of 1986. Sometimes people call it IRCA. So before 1986, there were no I-9 forms, but they started then, and they're used to verify. The point of them is they're used to verify the identity and employment authorization of all new hires in the U.S. So this is something that applies to all employers, unlike other companies, other statutes for companies that might have a minimum number of employees in order to be applicable. This applies to everyone. So the employee has a responsibility. The employees must attest to their employment authorization status and provide valid documentation to verify that they're eligible to work. And of course, the employer responsibility, which we're mostly talking about today, the employer must review the documents presented, verify the authenticity, and of course, accurately complete the Form I-9. And then you're also obligated to retain the forms, and Michele will talk about that a little bit later. So do, of course, is we like to start out with all the bad news. You know, you need to comply, definitely, and there are penalties, definitely. So as we go through the program here, just want you to keep in mind that there are some serious risks. Non-compliance with the I-9 requirements exposes employers to significant legal and financial risks. The penalties can be serious. That's the most common penalty, is a civil penalty. In other words, not a criminal penalty where, you know, someone goes to jail. You have to really do something bad to go to jail based on I-9 forms. It's possible, but not as likely as getting a civil penalty. So the fines for not filling out I-9 forms correctly, and Michele's going to talk about it just in a minute, what that means, range from $250 per violation. Not just someone comes in and says you didn't do this correctly, you owe $250. It's $250 per violation per I-9 form, up to about $2,300. Actually, I think that's risen very recently. I think it's gone up from $288 to about $2,800 per violation. So, you know, $2,800 per violation if you're a larger company and you have multiple violations, that can really add up. But the thing is, you know, you might say, well, that's a pretty big range, right? That's a factor times 10 from $288 to $2,800. And the Immigration Service will take into account various factors like the size of your business, whether the mistakes were made in good faith, how serious they are, whether the mistake caused an unauthorized person to appear to be authorized, and also the history of any violations that you had before. So if you're a repeat offender, then the violations are going to be greater. There are such things as criminal penalties. Those are for willful violations. Willful means, of course, you knew the right thing to do, but chose not to do it. That's pretty much the definition of willful. And then it could mean also that for those of you who are associated with companies that have government contracts, it could mean that you lose that.
All right, so who's responsible for the I-9 completion? So once an employee accepts the offer for employment, the employer can send the I-9 form to them for completion, not before the offer is accepted. The employee has a responsibility of completing section 1 of the form no later than the first day of work. They can complete it prior to that, after they accept the offer, but it's no later than their first day of employment. This is an area that a lot of employers really aren't aware of and could be an area where they're out of compliance. The employee provides the documents to prove their eligibility to work in the United States, as well as their identity, to the employer. The employer completes section 2 in its entirety and preferably retains the documents, although not mandatory unless you have E-Verify. And we'll get into that a little bit later in the presentation. And the employer has to complete the I-9 form within 3 days from the start. So if somebody starts on a Monday, that means by Thursday, that I-9 form needs to be completed, Section 2. So Section 1, that's the employee's responsibility. No later than their first day of employment after they've officially accepted the offer. They do need to provide their legal name, not nicknames, and they need to include past names as well. Complete address, date of birth, social security number is optional if they are not using E-Verify. So if you're using E-Verify, social security numbers are mandatory. I recommend it, but again, it's optional unless you use E-Verify. They also have to attest to their citizenship or immigration status. And this is another area that sometimes is missed, but it is very important. Sign and date. They cannot backfill dates. That is another area that employees or employers tend to do, not understanding the ramifications for doing that. So be honest, put the correct date. You can make a note if it's late. You have to always show that good faith effort. And then present the required documentation within 3 business days of starting work. So it's up to the employer to review that Section 1 and make sure that anything that was done in error is corrected by the employee. All right. Employer checklist. So again, the deadline for completing the Section 2 of the I-9 is within 3 business days of the employee's start date. If an employee is only working 3 days or less, then Section 2 needs to be completed on their first work day. So yes, an I-9 needs to be completed if they work only 1 day. It is mandatory no matter how many days they work. But again, by their first day of employment, if they're working less than 3 days. So the employer needs to provide the I-9 instructions and lists of acceptable documents to the employee. They need to review Section 1 for accuracy and have the employee make any corrections that are required. They are to physically examine the employee's identity and work authorization documents to ensure they appear genuine and relate to the employee. Now, we're not expected to be document experts, but you should be able to recognize if a document isn't authentic. You know, maybe there's a family picture that would not be on a professional or formal ID. I know that's a little bit of an exaggeration, but just to illustrate the point. And the Section 2 has to be completed in full, including the employee's start date, and retain the completed I-9 form. Now, employers can appoint someone else, an authorized representative, to complete the Section 2 on their behalf. So this really applies when you have a remote workforce and you're not able to complete the form, or there's not a manager present or someone else. So authorized representative can be the employee's family member, friend. However, if the employer identifies an authorized representative, such as the employee's family member, the employer is still responsible for completing the I-9 properly and on time. Just because they have somebody else completing it does not remove their responsibilities. So you're not required to copy employee documents and retain them unless you're using E-Verify. Then it's mandatory. However, an important detail is if you're copying documents for one, you need to be consistent and do it for all. So you can't copy for some and not for others. You just have to be consistent. It is beneficial to retain the copies of the documents so you have it for reference, ensuring your records are accurate, and it can help in reducing the risk of violations. And if you're making copies, make sure they're clear, double-sided if necessary, and legible, and uploaded to a secure portal. That's another, either retained in a secure way or uploaded to a secure portal, because it does have identifying information. So E-Verify. E-Verify is a free web-based system that's administered by the U.S. Citizen and Immigration Services. And it allows employers to remotely confirm employment eligibility through an alternative procedure. However, it is not a substitute for still completing the I-9. The employee and the employers have responsibility to still complete the Section 1, Section 2 of the I-9 form, inspect the documents, so it doesn't waive that requirement. But if you are using E-Verify, you can inspect the I-9, the documents remotely, but it has to be a live video with the employee. So that's really the only time you can do that. Otherwise, you have to have an authorized representative completing the I-9 form and inspecting the documents. And employers are not required to use an alternative procedure, but if you do use an alternative procedure for remote verification, for instance, you must apply it consistently and be sure it's without discrimination. So you can't decide that you're not going to do it remotely for someone who has a visa, for instance. You just have to make sure your practices are consistent amongst everybody. All right. All right, so we're going to talk a little bit more about the remote document inspection and verification. Again, within 3 business days of an employee's start date, employers who are using that alternative procedure must obtain and examine clear copies of the employee's documents, conduct a live video interaction where the employee presents their original documents, complete the I-9 form, entering all the details in Section 2, making sure they check the box for that alternative procedure, and finally retaining legible copies of all documents front and back if they're two-sided.
So there's a little bit of a misconception about re-verification, and in the way that I think most employers overestimate the number of re-verifications that must happen. You do need to re-verify in certain situations, but not as many as some employers think. So the employers must re-verify the I-9 when the employment authorization or receipt expires, as indicated in Section 1. But not all documents that expire are necessary to re-verify. So let's start with this. see the form there, and you'll see that, like, if you can see that, 1, 2, 3, 4, number 4 is highlighted. When you fill out the form, it'll have an expiration date, if any. That's where the expiration date goes. So how you re-verify is pretty common sense. You examine the new unexpired document. So someone needs to re-verify, show me the new document. You record those details, you fill out supplement B, but here's the thing, you need to do that before the document expires. So that process of re-verifying should happen prior to the expiration of the document that's expiring. And that makes sense, right? Because that way there's a continuous authorization. There's never a period where, someone expires on April 30th, and then you wait a week. Well, what if they don't have proper documents? That means that there was a week in there where they weren't authorized. But you never re-verify US citizens and non-citizen nationals. There's no reason to re-verify. Once they give you documents, US citizen gives you documents, fill out I-9, it doesn't matter if they give you documents that expire. For example, a driver's license. We get the question all the time. Well, when a driver's license expires, do we need to re-verify? No, not if it's a US citizen. Well, what about a passport? The passport's expiring. No, they're good. They gave you a valid document. We also get the question about green cards, permanent resident cards. You don't need to re-verify the green cards ever. So certain documents under list A and C, and if you happen to, I'm sure you don't have it just in front of you, this list A and C, but the I-9 form, of course, has the part you fill out is the first page, and then the second page are the columns showing list A, B, and C. List A and C, there are certain documents that are used to prove identity, and they do have expiration dates. List B, you never will verify anything in B, and then like I said, it's never required for US citizens. So I think Michele mentioned this, but it bears repeating. This comes up a lot with rehires. If you're rehiring someone, an employee, so in other words, someone who was working at your company and they left and they come back within 3 years of the original I-9 form, which would be hopefully the first day that they started or within a couple of days that they started, you can just simply complete a supplement and attach it to their previous I-9. That's enough. You would update the form with the rehire date, and importantly, the name changes. We do see name changes, fairly frequently, so that would be something. If you want, you can have them fill out a complete new I-9 form. Some people just don't deal with the supplement. They just say, look, we're going to start from scratch. So a new I-9 form is required if they come back more than 3 years. They come back 4 years, then you definitely need a new I-9 form. Or we just talked about, a few minutes ago, the new I-9 forms and how often they change and expiration dates. Let's say you had someone leave your company last August, and now they're joining you today. Well, that's certainly within 3 years, but the form has changed. The I-9 form has changed. So you will need to use the new form. So that's going to cover a lot of the rehiring.
There are retention requirements for the I-9 form. Number one, employers must retain the I-9 form and any supplemental pages along with photocopies of the documentation provided for as long as the employee is an active employee. Okay. They're not terminated. Once their employment ends, that I-9 form still needs to be retained with all the attachments 1 year from the employee's last day of employment or 3 years from the employee's first day of employment, whichever is longer. And it is definitely recommended to stay on top of those terminated I-9s and purge them accordingly, especially if there are errors on the I-9 form. If you don't have to keep it, you want to purge it. And we'll get into that a little bit more as we go. So storage of I-9 forms. If they are paper forms, you need to make sure they're in a locked access controlled area. So really they should be in a locked cabinet, be within a locked office. You should have that double protection. You want to make sure that only authorized access by those who should be able to see them. So you don't want, they don't want them easily accessible to managers, employees, of course, and even leadership. It's just not necessary. Electronic forms, you want to use a secure password protected system where there's backup and then there's audit trails. The key is limiting that access to authorized personnel only. You do not want to file I-9 forms with other records, such as employee files. They should be pulled from employee files and filed separately. And this is very important for a variety of reasons. First of all, you don't want any private identifying information in the employee files. Second, you don't want to have the I-9 form in there. Let's say there's a discrimination claim, and let's say the employee is there on visa. You don't want anything that could connect the dots to any job action, for instance. More importantly, if there's an audit or even an internal audit, it's going to be very difficult to be pulling those I-9 forms from the employee records. So definitely store them separately, and so that you can easily audit and pull them if there's a nice audit.
So in a way, this whole session is about common compliance pitfalls, right? We're talking about all the things where you can sort of stub your toe. Some things are bigger than others. This is a pretty good checklist of the most common mistakes to avoid, which is another way of saying the most common mistakes that occur. And again, kind of obvious that of the things that we're talking about, missing or incomplete forms happens a lot for various reasons. ICE will, if they do conduct an audit, and we'll talk about audits in just a few minutes, but if they do conduct an audit and they do look at your I-9 forms, they will look for very, very picky things. They will look for, boxes not filled out, dates that don't appear correct, clerical omissions, things like that. So the chances of getting audited are not huge, but if you do, then they really will take a close look at the forms. Completing the forms late, easy to do, right? In the chaos of hiring and when people start and everything else, as Michele said, you have 3 days to do it. If you don't do it within 3 days, that's a technical violation. Probably one of the most common that we see, at least from the attorney side, is improper document handling. Requesting specific documents or rejecting acceptable ones can trigger discrimination claims. So that would be an example of the employer or who's ever doing it, could be one of you folks in HR or otherwise. You can't make your own decision about what document you will accept if they were all acceptable. So if someone has a document that's on list A, you're not allowed to say, you know what, I don't want to see that. Don't you have don't you have an authorization card, or don't you have a passport, or that's all we accept. One of the things that ICE might even be likely to do is if they look at your documents in, let's say, an audit, and they see that you have 80 employees and 78 of the I-9s all showed you a passport or whatever, that might lead them to say, wait a minute, that's not random enough. That looks pretty consistent, that maybe you were, making your own decision about what you would require, and they might comment on that. The next common mistake, as we talked about, is using an outdated version of the I-9. That happens a lot. We do get the question about, oh no, I didn't realize that there were new I-9 forms and we've been using an old one. Do we have to go back? And generally we say no. Don't go back and re-verify someone that's been working for you for a few years, even if you used an older form. It's not perfect, having that information, but on balance, we usually say don't. Poor record keeping, skipping re-verification. We talked about the re-verification, and mishandling remote hires. And the remote hires, as Michele touched upon, that's been changing, how you handle remote hires. It was different during COVID. They changed the regulations now. The one important thing to remember, though, about these common mistakes is any employer might get fined, or you're subject to fines and penalties, even if it doesn't lead to someone being unauthorized. In other words, the employee might be perfectly fine and perfectly authorized, but if the I-9 form is incorrect, there can still be fines and penalties because the I-9 form is incorrect, even though it did not lead to an unauthorized employee working for the company.
Audit. So when we're talking about an internal audit, you are conducting that. Or if time doesn't allow for someone internally, an authorized party, to do that audit, you can outsource it. We have been involved in audits for organizations just because they just don't have the capacity to do it. However, the key here is to perform that internal audit. It's proactive. It will help you identify whether there are errors that need to be corrected. Maybe you're gonna find in a random audit that your I-9s are pretty good, and therefore you don't have to do a complete audit. However, a lot of times we do find that there are various errors, and they're common. So you want to do this because you want to demonstrate a good faith effort should there be an ICE audit to reduce your legal and financial risks. So the first thing you need to do is gather all your I-9 forms. This is why it's easier if they're all in one location together, whether it's electronic or paper. You want to make sure that your current employee I-9s are separated from your terminated employee I-9s. That will make your job easier, and therefore you can start auditing your active employees first. And then, of course, you designate someone to do the audit. Is it an HR professional, some authorized legal or compliance partner, whether it's outsourced or not, but you do need to designate someone. And they need to know the requirements and anti-discrimination protocols. In addition, I recommend you create a spreadsheet of your active employees and your terminated employees with dates of hire, termination dates, and that will help you in easily identifying the I-9s that you can purge if they're inactive employees. And you want to have enough information on that spreadsheet that documents your audit. So, including what the error was, what your findings were, and how you corrected them. And so when you're reviewing the I-9 forms, you're checking for information that's missing, timely completion. It was the I-9 form the appropriate I-9 to use, so if there are errors in section 2, you can make corrections on the I-9 form. You cannot make corrections on section 1. The employee would need to do that, but you can make a note. You could identify that you notice that they put their birth date in where they should have their start date, for instance, and initial it and date it. But you can't make the change. You can't plug in the correct information, in other words. You could just identify that there was a mistake in what it was. For major errors, a new I-9 form should be completed with the attached explanation. So there's such a thing as a correction memo, and there is something that it might be in the handbook, the I-9 handbook, or SHRM put one out, but I've also created one. And it's this way you can check off exactly what the problem was on the I-9 form and attach it to the I-9 that was audited. Never ever backdate. We said this earlier. Be honest. Just document that the incorrect start date or it was out of compliance and you didn't complete it until late. Maybe a reason, if there was a reason, like HR in transition, not aware of the I-9 requirements, and then initial it. Document the audit. That's why using a spreadsheet to document the details and the findings is great, because you can always pull that and show that if there's a nice audit, and it's good for record keeping. And in order to do it correctly moving forward, it's recommended to train those staff that might be completing the I-9 form, conducting regular audits of the I-9 forms, and standardize your procedure. Make sure it's just part of a process of onboarding new hires. It's automatic, it's standardized, and you have it in your procedures.
Yeah, what to expect. So look, I think you can all imagine this does not happen every day, to all of you or to all of us. How often does the government, any government agency, come knocking at your door? Not very often. Many people have the experience of OSHA coming in, because those are kind of frequent visits, a lot more frequent than others. Some of you might have experience with wage and hour coming in and looking at payroll records and that sort of thing. ICE is different. ICE is different. When wage and hour comes in and when OSHA comes in, they don't have, vests on with weapons, with police hats and all of that. It's just a different context of what happens. So this is some general advice, and then I'll expand upon it a little bit. I think if this happens to most people, it's sort of chaotic. It's hard to think clearly about it. What do we do? What do we do? So it's really good to kind of, I don't want to say practice, but maybe think your way through it, just like you would, a fire drill or an emergency drill or something like that. Okay, what happens? Who should be the person, assuming that they're, on site at that point, should be dealing with this. So stay calm. You do not need to consent immediately to what they're asking for. And I'll talk in a second about the different things they may be asking for. You can ask the agents or whoever's there to wait in a neutral area while you notify the appropriate internal contacts. So that's an instruction to your employees. Just don't let them in. Keep them in a public area, neutral area. Wait a second. I need to call so-and-so. I need to call the owner of the business, or I need to call director of HR. I need to call someone. As I mentioned a minute ago, contact legal counsel. It would be ideal if you could contact legal counsel and get advice before anyone says anything or lets them in. Some of the nuts and bolts of this, you can request identification just like you would with any law enforcement personnel. You can get the agent's name, the title, the agency. If they do have a warrant or something that looks like a warrant, you could ask them to copy it. Hey, can I make a copy of this for our records? And you can tell your people, don't volunteer information. They're not obligated to cooperate with the ICE agents that appear. You don't have to tell them, let's say they're there to question or maybe even detain an employee of yours. You don't have to tell them that the employee is there. You don't have to tell them that they're working that day. You don't have to escort them to the employee's workstation. You don't have to do those things. So it's good to kind of think through it. And if you are concerned and you think you might be more likely to be subject to an ICE audit than maybe other businesses because of the nature of your business or your workforce, the general advice would be let's get an immigration attorney to give you some like a specific consultation about what you do in that situation. So this gets pretty technical. And you're not expected to be immigration attorneys and you're not expected to be law enforcement, but some of this does get a little technical. If someone shows up from ICE, they could show up without anything, without any documentation. And then again, you're not required to let them in. But there's basically two different types of warrants. There's what they call an administrative warrant, where they might be asking for certain information, administrative. And then there's a judicial warrant. And a judicial warrant is what you see on TV, right? A judge signed it. They went to a judge, usually a federal district court, a federal court, and a federal judge signed a warrant. If someone has a judicial warrant signed by a judge that says, we're authorized to come in, they're authorized to come in, then that's a different story. Then you do have to let them in and execute the warrant. So how you determine whether something's a judicial warrant or an administrative warrant, again, generally speaking, a judicial warrant signed by a judge. But obviously, if you're at that point looking at warrants and trying to figure out, what did that guy say, judicial and what, then really it'd be good to have have an attorney there. So there's an administrative inspection. Getting back to I-9s now, not just a general, ICE raid where they're looking to detain someone, but an I-9 audit. They show up and they only want to look at your I-9s. They would have an administrative inspection, an administrative notice, and they would request your Form I-9s and the supporting documentation. You don't have to give it to them right away. You don't have to say, wait here, we'll go copy it. Or you don't have to escort them into, the Director of Human Resources offices where you have the file drawer that Michele talked about with all the alphabetical files. You don't have to do that. You have 3 days to comply. So use that time to speak with an attorney, review your records before you turn anything, over. If there happens to be a real warrant where they are allowed to come in right away, again, then that may or may not authorize physical entry. I have to say, I've never heard of a judicial warrant from a judge just for I-9s. I mean, I think it's happened in rare circumstances where, there are a variety of, there's bad past history and there's repeated violations and all of that. But I think just for I-9s, you're likely to have that time, that 3 days. As we said, there are criminal search warrants, and then you can't interfere if they do bring up one of those judicial warrants, those criminal search warrants. And then there's a raid, an actual raid, an unannounced immediate action. That would be with multiple agents. They would detain people. There'd be on-site questioning. That would be a very, very serious matter. If that happens, then you would not interfere. And again, call an attorney for that situation. A little bit of common sense here. The more information you can get, I mentioned a minute ago, the agent's name, how many of them are there? Are they accompanied by local law enforcement? All of that would help just to kind of reconstruct later if there is some sort of objection that you're going to make later. I will say that generally speaking, the chances of you being subject to an I-9 audit are slim. They do conduct audits, of course, and in this environment, they do conduct more than they have in the past, but the chances of any particular business being audited are fairly slim. They are caused by, number one, someone will report the employer and say, I believe there's violations, or there's information that gets to them from some other source, or it's random. They do focus on certain industries that are more likely to have immigration problems than others. So there are various ways that there can be an audit or a visit. So.
So just to repeat and emphasize, make sure you're using the correct version of the form. Those that were hired prior to November 1986 do not need an I-9 form for any of those that might have an employee that's still with them for that long. Again, can't emphasize enough, just make sure your process for completing I-9 forms is standardized and it's part of that new hire onboarding. I recommend you at least randomly audit your I-9s. And if you find a number of errors, then you should just completely do a complete internal audit. Make sure you're training whoever is an authorized representative of how to complete the I-9 properly, and make sure that those authorized representatives are, responsible. They understand the importance and the seriousness of completing the I-9s correctly. Even though you can have a family member age 12, I'm not sure I recommend using the 12-year-old family member, but for some reason that is allowed. And make sure the storage and the access of those I-9 forms are controlled and limited to only authorized personnel. And like Mike talked about, preparing for those audits. Always good to be prepared. Talk to your attorney about what you need to do. Have a plan in place should there be an ICE raid, so to speak. And engage in an HR professional or legal counsel when in doubt, or if you need assistance.
As I mentioned in the beginning, there are some really, really great resources on I-9s. The handbook for employers that you see there, the USCIS form resources. I mean, online is great, but the handbook is really very good. As a matter of fact, we have immigration attorneys that that we deal with all the time. And every once in a while, there'll be a complicated I-9 question that I'm thinking, wow, I've never come across that before. And I'll contact the immigration attorneys, and the first thing he says, Mike, did you look at the handbook? Did you look at the I-9 handbook? Nope, I just called you. But the answers are very, very often in these materials. So highly recommend them, and they're free.